Johnson, are you ready?
I am.
Mr. Barker, are you ready?
Yes.
Ready, Jenny?
Yes, I am.
Okay. Then we'll go on the record and file 15 CF 627, a case entitled State of Wisconsin Plaintiff versus James A. Barker, the third defendant. If you'd state your appearances, please.
Good afternoon. Haley Johnson for the state as a special prosecutor.
James Barker, pro se.
All right, then we're here today for us scheduled for a pretrial. And we had talked before at the end of the last hearing, I believe, and probably previous to that, about certain issues that we, in light of the fact that Mr. Barker is not a lawyer representing himself, we wanted to try to do some more work on than might be normally done in preparation for a jury trial so that we can make it run more smoothly. And one of the things that we talked about was questions that would be asked during voir dire. And the court had requested that the parties prepare questions that they would want to ask during voir dire so that we could see them. I intend to decide whether or not the parties will be able to ask their own questions, or as is often done in some courts, the court asks all the questions that the parties want to ask in voir dire. So has the state had a chance to prepare any voir dire questions?
I have previously filed voir dire questions.
Okay, when did you do that so I can look in the computer here? Give me a date.
Let's see if I can find them. I filed them back in May 18th.
May 18th.
Rather, May 16th.
Okay. All right, I see them here. Yeah, they're here. Okay. All right. And Mr. Johnson, or Mr. Barker, did you receive a copy? It's a
Of
two-
what she filed? Yes, I did.
It's a two-page document, okay? So
Yes.
you know what the questions are that the state wants to ask of the jurors. Let me explain to you, in the process of jury selection, we ask jurors questions about their qualifications to serve as jurors, all right? And it's not an opportunity to ask them questions about the facts of the case, but to ask them about various things that might reflect on their ability to be fair and impartial in a case like this, okay? Have you had a chance to prepare any potential voir dire questions?
No, I have not.
Okay, do you intend to ask questions on voir dire, or do you want to ask questions?
Yes, I do.
Okay, and when do you think you'll be able to have those prepared in writing so that we can review them?
Well, actually, I did start asking the questions, but I haven't finished preparing the questions because I still haven't got all the discovery.
Okay, when will you have your questions done?
Whenever the state comply with discovery.
Okay, well, we'll get to that in a moment. All right, we'll set a date here a final date when you'll have to have voir dire questions filed. Otherwise, you may not be able to ask any yourself or to have the court ask any. It's just that simple, okay? So the other things that we need at a pretrial are witness lists. Ms. Johnson, has the state had a chance to prepare a witness list?
Yes, Your Honor.
And that was submitted?
It was, and I believe it was provided to the defendant previously as well.
Okay, do you recall exactly what date that may have been submitted? There's 250 documents here, so it's hard to put them.
I'll see if I can
What's
find it.
been filed here? Defendant's updated witness list filed May 3rd. April 23rd.
I don't see the states.
Mr. Barker, do you recall receiving a witness list from the state?
Yes, I do believe I received one. I believe one was filed. Yes.
I can refile it to be safe.
Okay. You have it there in hard copy or no?
No.
Okay. So, when you will be able to do that? By the end of this week?
Yes.
Okay. All right, so we'll have the witness list then. What about potential jury instructions? Have we had a chance to prepare a list of proposed jury instructions?
No, but I can do that by the end of the week as well.
Okay.
What we have for our office is a list with all of the instructions,
Yes.
with the box that can be checked, and I can include the
Okay.
substantive
All right,
instructions as well.
okay. And then we'll give that to Mr. Barker as well, all right?
Objection. Question.
Yes, go ahead.
As far as Brady versus Maryland, the letter that I received from Zeke Wheatonfield, are we going to address that issue, or are we just going to act like Lieutenant Chauvin is not all over the news?
Okay,
Sorry.
we'll get to that, all right?
Okay.
We're talking, this is a pretrial. You keep filing motions, and technically, motions have to be filed within a certain amount of time of the various events. And I've given you considerable leeway here. Every time we go away from court, you file more motions. This case, may never end if we let you keep filing motions. But we'll talk about the two things you raised today when we get to the end of this, okay?
Objection. I believe we should talk about that now. This is very serious. I received a letter, so you,
Okay, let me talk to you about your representation. You're here today without a lawyer, right?
I'm my own lawyer.
Yes. Are you choosing to be your own lawyer in this case?
Yes.
Okay, and in the past, as I read the record here, before I came to this case, you had 9 different lawyers.
Yes.
And then I've been informed by the public defender's office that they will not appoint any more attorneys to represent you, even if you wanted one, right?
I don't
Understand
even
that?
want a public defender.
Okay, all right. So basically, you understand that by appearing on your own, you're giving up your right to be represented by an attorney, right?
Do you understand that there's been 6 different DAs and 3
Okay.
judges on my case as well? That
Okay.
equals 9 too.
Okay, answer my question. You're giving up your right to be represented by an attorney when you appear on your own. Do you understand that?
Yes.
How far have you gone through school?
I graduated.
High school?
Couple college
Okay.
business
Couple of years or credits? or
Credits,
what?
yeah.
Okay, what sorts of credits did you take in college?
management.
Okay, through like Gateway or someplace? Or
Something
what?
like that.
Okay, all right. So a technical school?
Yes.
Okay. And have you've been in court before? Obviously, you have been on probation as I look at your record, and you've had prior contact with the court system, right?
What do that have to do with what we're talking about today?
Because you have prior experience with the court system. In the past, you've been represented by lawyers, right?
Yes.
So you know about what a lawyer is trained to do, that a lawyer goes to school for 3 years beyond college, gets a degree, and is trained in the law and legal concepts, correct?
I may know. I don't know. I don't have any experience with law school, so no, I do not know.
You understand that a lawyer is someone who is trained in the law, who might be aware of legal issues and procedures that you may not know as a non-lawyer. Do you understand that?
Well, no, I do not, because I know exactly what I'm doing. So,
Okay. So you're choosing to give up your right to have an attorney represent you and you want to represent yourself, is that correct?
no, it's partially correct. The only reason why I'm choosing to represent myself is because this county will not release my $15,000 for me to use use my Sixth Amendment to get an attorney. And so I'm not going to use a public defender. I would like to use the attorney of my choice.
Okay.
So therefore, I'm forced to represent myself before I allow the state to represent me on the behalf of the state. You know, it don't even make sense to me.
Have you tried to get an attorney to represent you other than the public defender?
I have paid attorneys, yes.
I'm sorry, your microphone broke out there.
Yes.
Okay, and who did you talk to, may I ask?
That's private. I don't know. I don't want to share that.
Okay, were they lawyers in Racine in private practice or out of the county or where?
What do this have to do with my case? I'm trying to get to a point, and we're just taking up time by talking about my attorneys in my prior past. And I'm sitting here today trying to represent myself in this courtroom, and I just want to exercise my constitutional rights to make my argument. Can I petition the court?
It's my job to make sure you understand the rights you have and that you give them up freely and voluntarily, okay? And having an attorney represent you is a very important right. That's why I need to talk to you about it and dwell on it for a period of time, all right? We'll get to the issues you want to talk about, but I need to ask you some questions about you giving up your right to have an attorney represent you. And again, if you're indigent under law and qualify, the public defender's office will normally appoint an attorney, but because you've had 9 attorneys appointed to the public defender's office, they're no longer willing to appoint an attorney to represent you.
Objection. That's not true. I did not have 9 attorneys.
There are 9 attorneys entered in the court record. I've counted them. That's what the record
I'm
shows.
telling you, Laura Walker was not my attorney. She was my co-defendant, Josh Golden's attorney. It was another attorney on there that I never met before. During my time of looking for to retain an attorney, the state automatically appointed them as my attorney, but we never met.
Okay, well, whether it's 9 or whether it's 7, whatever it is, the record in the computer shows 9. I've counted them several times now.
Do the record in the computer show how many times the DA has withdrawn from my case?
Okay, that has nothing to do with what we're talking about, all right?
All right.
So, at any rate, if you want an attorney, you have to either hire one on your own, and you've tried to do that, is that right? You've talked to some attorneys, you said, is that correct?
I may have.
Okay. And have you ever gone through a trial process before? Have you ever had a jury trial in your lifetime?
No, I have not.
Okay. Have you've been in court though, with court proceedings, motion hearings, and various proceedings such as changes of plea, perhaps sentencings and so on? Is that right?
Yes.
So you're familiar with courts in the general sense in terms of how the procedures work and how they affect you as a defendant, correct?
Yes.
And it's, again, your wish to continue to represent yourself in this matter?
Yes.
Okay, all right. Any questions about that?
I mean, all the questions I have never seem to matter to this courtroom anyway, so, no, I do not have questions. I just want to get on with what we're supposed to do.
Is anyone forcing you to give up your right to have an attorney represent you?
Yes, the Racine County Justice System, they're illegally withholding my money, violating my Sixth Amendment rights to an attorney by not releasing my bond money. I've been drugged in and out of court on a case where the state has admitted they have no evidence. And I'm still coming to court, and now, after June 4th, after I just played the video of Lieutenant Chad Showman executing a fake search warrant on my property, which is a violation of my Fourth Amendment right, all of a sudden the DA let me know that he's under criminal investigation for doing the exact same thing that I've been accusing him for, which is stealing.
Okay.
And
We'll get to that in a moment, all right? So, anything else you want to say or ask about your giving up your right to have an attorney?
nothing.
And I'll find, based upon the circumstances here, even though Mr. Barker says he wants to hire an attorney, but he doesn't have the money, he's tied up in bond, he has, by his conduct and his number of attorneys he's had in the past, in effect, waived his right to be represented by an attorney at this point in time. I'll find he does so freely, knowingly, and voluntarily, and allow him to proceed on his own as he wishes. Now, one other thing, has the state ever extended an offer to Mr. Barker to resolve this matter?
No. Well, in the beginning of my pretrial conference, David Sedana pulled me out in the hallway after I told the courts that I did not want to waive my pretrial conference. My pretrial conference. He pulled me out in the hallway and said that Patricia Hansen stated that they would drop the THC case if I waived my preliminary hearing. I mean, not my pretrial conference, my preliminary hearing.
Yeah.
So, but to this day, I'm still facing charges of possession of THC and drug paraphernalia that wasn't found in my person. It was actually found in somebody else's
Okay,
house.
you don't have to go into
allegedly.
the facts about the case, just about whether or not anyone's made an offer to you to resolve this case, a plea
No.
negotiation. Okay. Ms.
There-
Johnson?
There was some discussion with one of his prior attorneys, and I can't recall which one, about resolving the case, and the attorney's position was that Mr. Barker would only plead to misdemeanors, and I was not inclined to offer misdemeanors. My understanding after that was that Mr. Barker wanted a trial. I could still extend an offer if that's something Mr. Barker is willing to consider, but my understanding is he simply wants his case dismissed.
Exactly.
So would you consider an offer if one were made to you, Mr. Barker?
If it's dismissed, which I'm due for outright dismissal.
Okay, well, they're not willing to do that, is that correct, Ms. Johnson?
Correct.
So you're not willing to consider an offer other than a dismissal, is that what I hear you saying?
Trial. That's it.
Okay, all right. So,
Now, before we get to the trial, this
no,
is,
no, I'm in charge here, you're not, okay?
okay, go ahead.
So, one of the issues, if you read Mr. Barker's submissions, he wrote a letter to the court, and he also filed a motion. These were filed with the court on July 30th, he wrote a letter to the court. Did you receive a copy of that, Ms. Johnson?
I'm not sure that I did. Was it e-filed?
Yes. Says carbon copy to both you and to Mr. Wiedenfield, Bell, better. Filed July
Oh.
30th.
Yes, I did receive that.
Okay. And then he filed defendant's brief and motion to suppress evidence. That's the title of the document filed on August 3rd. You see that?
I did get it. Yesterday I was in a jury trial the past 2 days.
Okay. So, the gist of what he's raising, one of the things he raises is the issue of Lieutenant Chad Schulman. Could I ask whether Lieutenant Chad Schulman is a witness in the state's case?
He is listed as a witness.
Do you intend to call him as a witness?
I intend to review his participation to see if I need to call him, considering his new issues. But since he was involved, I did have him on my witness list,
Okay,
and that's why I notified Mr. Barker of his
all right. So as long as he's on the witness list, then Mr. Barker may be entitled to information that relates to underlying issues that are not in this case, but in another case where there's an issue of apparently some money that was, I'm not sure I should put it, missing
Stolen.
in another
Yes,
matter, in an investigation.
yes.
And what is the state's position on releasing that information to Mr. Barker, which I think he's entitled to if you're going to call him as a witness?
Right, I do agree Mr. Barker is entitled to that information. The problem is that Mr. Barker has multiple social media accounts where he posts information about the case. He's gone to the news, he's been on a local TV show, many forums for public discourse Mr. Barker uses to present information about the case that is not always accurate. The state doesn't have the opportunity to respond. So I do want to give that information to Mr. Barker. What I would like to do is ask the court for a protective order for Mr. Barker to no longer post any information about the case, the officers, the court, and parties on social media that could potentially taint the jury.
Objection.
I was informed this morning of Mr. Barker posting the photos of many of the Racine County Sheriff's Office deputies, and captions under some of those photographs were very inflammatory. One officer was called a pedophile. Some of that information has been taken down from his Facebook page, but there have been comments about killing officers, raping them, things along that line. The main concern, because none of the threats were from Mr. Barker. I just want that to be clear. But the main concern for the state is that Mr. Barker posts information related to the case. I don't want the potential jury pool to be tainted. So if there's a way for Mr. Barker to stop posting about the case, stop talking about it in the media for now, certainly he can talk about it in the future, but until we have the trial, I would like him to not share any information about the case. I would like to give him those reports, again, with the protection order in place or an order from the court for him not to disclose that information until the time of trial.
Objection.
Okay, you want to make a statement in
Yes, I
response
do.
to what you said? Go ahead.
Well, in the likes of Brady versus Maryland, first of all, it's a criminal case. If I call, just like my case is public record, Lieutenant Chauvin, just because he's a lieutenant, doesn't free him from being publicly criticized, especially holding a high position like he did. And he's stealing evidence out of, allegedly stealing evidence. And this is the thing about Lieutenant Chad Chauvin. Now, this investigation I learned through TMJ4 News, Brandon Rook, that this investigation allegedly took place, started in October 2017. Since October 2017, I've been in court 7 times. And I personally handed and emailed between Haley Joe Johnson and Zeke Wiedenfield, Prosecutor Zeke Wiedenfield, the DVD copy of Lieutenant Chauvin executing a fake search warrant on my property. I also filed on August 30th, 2017, a written transcript describing exactly what was going on inside on my property as Lieutenant Chauvin executed the fake search warrant. And through all that, June 4th I played a video in the courtroom, and then all of a sudden they released the information. That right there is a violation of my due process rights. Brady versus Maryland, you can't conceal a criminal case from the public, especially when they're trying to prosecute me using him. The 252 grams of THC that came up missing while I was in jail. All of a sudden, April 26th, allegedly, I ended up with a marijuana case.
Okay, well, let me ask you a question, Ms. Johnson, regarding not this case, but any case investigation that's going on with respect to Lieutenant Schulman. Do you know where that is in its process? Whether it's completed, whether it's ongoing, whether it's been submitted to the DA for prosecution, or what is its status, if you know?
I know it's been submitted to the DA for prosecution. My boss, District Attorney Wiedenfeld, is the special prosecutor. I don't believe any charges have been filed yet, so I'm not sure of the procedural position of the case. That's why I had told Mr. Barker about the case, and I sent him the letter regarding the basic information and told him that I wasn't able to give him the reports at this time.
With respect to this particular case, the matter involving Lieutenant Schulman, has there been, Mr. Barker makes reference to one media disclosure of it. Has there been other media disclosures of it that you're aware of?
I'm not aware of the number of media disclosures. I know Mr. Barker was in contact with the media and provided the letter, so there was a story stemming from that. I would imagine there were probably others. I haven't searched all of them.
I can answer that question. Yes, TMJ4, CBS 58 News, a headline in the Milwaukee Journal, and also Journal Times. Yes, so yeah, Lieutenant Chad Chauvin, Brady versus Maryland is very simple. They concealed exculpatory evidence from me all the way up until June 4th when I played the video.
We understand your position there. Let me ask you this. She's asking that if it be released to you, that it be released under a protective order, that you not be allowed to disclose it to the media or to anyone, not to put it up on a website, but just to have it yourself for your use in this case, at least until this case is over and until perhaps some decision is ultimately made with respect to whether or not there should be charges against Lieutenant Schulman. What is your position there?
My position on that is supposed to be public record. If I catch a case, if I get to become under investigation, it's become public record. I'm fighting me against the entire Racine County justice system. I go to the public to let them know the cruelty and punishment that I'm suffering in the hands of you, Haley Joe Johnson, the entire Racine County justice system. So the only people that I can reach out to is the media. So therefore, I go to the media and let them see what all the corruption that's going on right under in your hands and Faye Fletcher hands, Judge Eugene Gashikevich.
Okay, you don't have to go through everybody. You don't have to do all the listing. You know the history of the case, okay? Save yourself some of the words and us the time.
Well, I'm just stating the record of what's going on.
Let me ask you this. If you were to be given those reports from the Schulman matter and were instructed and ordered not to disclose them to anyone but to yourself in the context of this case, would you comply with that?
Let me ask you this. Is it legal for me?
I'm asking you the question. You're not asking questions here. Would you comply?
If it's legal, if I'm not into breaking the law. So if it's illegal for me to, if you can show me a statute where it's illegal for me to.
All right, what then I'm going to do is I'm going to order that Ms. Johnson provide the reports to the Racine County Clerk of Court's office, to Amy Vanderhoff, who's the case court manager. She will make them available to Mr. Barker, who will be allowed to review them at the courthouse in an office, in the clerk's office. No, listen, and you may not take pictures of them, you may not record them, you may look at them and read them, and they'll be available to you in that context, but I don't want them outside of the context of this case, since you're not willing to assure me that you would comply with a court order not to disseminate them. What we're worried about here is the issue of making public information available that could taint potential jurors and make them unable to serve impartially in this case.
Okay.
So to protect the record here and to protect the potential jury pool, I'll give you access to those records under those circumstances. But since you're not willing to comply with a court order that says you can't disseminate them to anyone, you'll do that under those circumstances.
Okay, well, I say I won't put them out in the public. Just give them to me. I won't put them out there in the public.
I understand. Now you understand. Now you change your story based upon understanding the circumstances. But I'm not willing to take that chance based upon your history here and your position and so on. So
I just said I won't put them out in public. I have a right. Brady versus Miller. I have a right to all of this.
you do have. And you will have a right to see them and to read them and have access to them under those.
I don't have time to be coming down to the Racine County Clerk's office looking at records.
Okay.
This is a violation of my constitutional rights. You are violating the Supreme Court law of the land.
Okay.
You're overthrowing the government, the rules. You like Supreme Court. You don't even have authority to overrule over Supreme Court decision. Supreme Court states that I have a right within in color Brady versus Miller to those records that you're trying to tell. I don't
get access to them.
I'm telling you,
come to the courthouse and look at them. Okay?
I'm telling you, I will not.
The next issue. The next
Okay.
issue is you wanted to get
This shit.
the reports of interviews with Cree employees. Is that right?
No, I'm still on the Brady versus Maryland
Okay,
issue.
We're moving beyond that. That's decided.
Objection.
I've given you access under the circumstances I've described here. Let's
It's
move on.
more to that objection. Can I get the same respect that you give the DA or the DA? You're showing your partiality by cutting me off every time I speak. I'm trying to make a point. You never let me get to my point. That's all I'm trying to do is get to my point.
Go ahead and get to your point.
I'm trying to tell you, I do not have time to be coming down here to be looking at records, dealing with Racine County Sheriff Department. I done been through that. It always end up the runaround for me. I'm telling you that I will not release any of those records to the public at all. So I just want you to allow me to have those records so I can sit at home at my own time and review them versus trying to come down here and getting a runaround like I've been getting when I was chasing after the search warrants. I don't have time for that. I have a life, I have kids, so I cannot be coming down here depending on Vanderhoff or anybody else to have to provide me with these documents. So I'm objecting. I really need those records to take home with me, and I'm not going to release them to the public. But as far as the Brady versus Maryland, Lieutenant Chad Shulman is all over my case from the TAC.
I agree with you. You're entitled to access to those records, and I'm giving you access under the circumstances I've described. Okay, so we're not going to go any further with that issue. We're going to go on to The other issue you raised, which I read in your submissions today, is about interviews with Cree employees. And Ms. Johnson, are those reports that you have in your file? Apparently, he's alleging that Cree employees, 20 or so, were interviewed by various law enforcement officials?
That was in his August 3rd submission?
Well, here go the police report from Lieutenant Chad Showman and also Deputy Daniel Showman. Deputy Kelly Ghosty, or however you say his name. Here's the report. The Danielle Showman June 23rd report, and in here she names all the interviews of the Cree employees that was interviewed, audio recorded, and also, it's audio recorded, and she described her and her husband, Lieutenant Chad Showman, and Deputy Ghosty interviewing, and they was audio recorded. I've never seen those 20 plus interviews, and I never got those.
Can I review that report, please? I don't believe that I have those recordings. I can check on that today.
All right.
But you stated that you submitted all the discovery, so you were admitting in court on record that you withhold the discovery after you already you stated on record and filed saying that all the defendant.
Don't argue with her, talk to me, okay?
Well, she stated that she filed with the witness list and all that, stating that she had complied with the demand for discovery and the motion to compel. Now here we go. There's 20-some interviews missing. They testified to destroying all the search warrants. The August 21st, 24th interview with Josh Golden has been destroyed. The April 23rd, 2015 interview with me and Vanderbilt has been destroyed. The April 23rd, 2015 interview with Yvonne McNeil has been destroyed. And now we got Lieutenant Chad Showman, who's been under criminal investigation, who's on camera executing a fake search warrant on my property. And Zeke Wiedenfield stated that he believed in his letter to Patricia Hansen that he believed that Lieutenant Chad Showman was being untruthful in far as his investigation of Lieutenant Chad theft of money from a dead body. And so she's sitting here saying that she's planning on using him as a witness for the state when she know that he's, her own boss told her and stated in the letter that he's a liar. And so you're saying you're going to use him as a witness?
Don't talk to me, not to her. She's already indicated he's on the witness list. She's not sure whether she'll use him or not. That's what I heard her say, okay?
But the case is tainted. He's handled all kind of discovery on my case, Brady versus Maryland. You've been a judge, how long you said, 25 years? And you're not familiar with the Brady versus Maryland case?
Never said that, okay?
So
if she doesn't call investigator or Lieutenant Shulman, all this goes away. You understand that?
I'm going to call him. I need his information because I want to subpoena him. I want to find out.
Subpoena him, that's fine. Let's see what happens.
And see what happens. What you mean by that? Can you recollect what you mean by, well, let's see what happens?
We'll see what happens when he's called to the witness stand, like every other witness, okay?
So you're telling me that you're not willing to dismiss this case on the fact that Lieutenant Chad Showman...
We've already gone. We're not dismissing this case today. It's going to go to a trial, and the jury will decide whether you're guilty or not guilty, okay? You've made the motions. Every time you come to court, you make the same motions. I've already denied the
It's not the same. Objection.
okay?
Objection.
So, with respect to the pre-employee interviews, you're gonna see whether those exist then and provide them if you find them, Ms. Johnson?
Yes, Your Honor.
Okay. So
Question.
then the last thing we're going to talk about today is the date. There was a motion made by the state for adjournment of the jury trial, is that correct?
Correct.
And that's supposed to have been starting tomorrow, which obviously is not going to go forward at this point in time, but I want to hear your position, Mr. Barker, on whether the matter should be adjourned or not.
I'm still on the pre-employee interviews. So you said you're going to ask, see if whether they exist or not. I mean, so okay, if they don't exist, then what? Is that spoliation of evidence?
Well, she'll file a letter with the court about what she finds, and you'll get a copy. We'll take it from there, okay? We don't know.
This is ridiculous.
We don't know, okay?
You up there, you're
Okay.
supposed to uphold the oath.
Okay,
And you're sitting there.
October 30th is the date. Anything you want to say about it?
October 30th.
Yes.
For the trial?
Yeah.
No, I have no objection, but I do want to present my motions.
You did.
I didn't present my motion. Did you see me read a motion?
You're not going to read anything because we've got it all printed here, okay? We've done that before. You don't read documents that you file. I've read them all. I know what they say, okay?
Oh, so you don't agree with nothing inside my motion, huh?
I've helped you by trying to deal with the Chaz Schulman issue and getting you the reports and access to them as you've asked for. And we're looking for the pre-employee interviews, all right? So is there anything else you want to say today?
Yes. The state received a 6-page, just a second. Can I ask her a question about the affidavit? Did you receive this affidavit from Christopher Nail?
Yes.
So are you still? She took full responsibility of the alleged grinder filled with marijuana.
Let me explain something.
Yeah.
A witness might say something different today as compared to tomorrow. The state has to decide whether they want to go forward with the case.
Yes, that's
That
right.
witness is called to the witness stand, then the state will present the witness's testimony. If the witnesses change their testimony, they may try to impeach the testimony of the witness if they change it by what's called prior inconsistent or prior statements that they've made that might be different, okay?
Objection.
So it's not up to the court to decide whether to dismiss a case based upon the fact that you have an affidavit from a witness who said something different.
This
It'll
is
be
my
up to the
witness.
jury to decide whether or not the state has proven that you're guilty beyond a reasonable doubt of the charges they brought against you.
Objection. Can I speak up more? Can I get cut off? While this is a 6-page sworn affidavit from the person who house it was. I'm being charged with THC that was allegedly found in a house that I wasn't in and isn't my registered address.
So let me explain to you what will happen. The jury will hear those facts. You'll present the facts about saying you didn't live there. The jury will hear the facts from the state about the things being found there and identifying documents, which I think I read were found near those things that had your name on it.
Yes, I got
The jury will decide whether you had possession of them or not. That's the jury's job, okay?
Now, so you're telling me that I have to go to trial. I'm filing a pre-trial motion to dismiss. And so I'm looking to get these charges. Why would I have to go to trial and fight a charge that the person who probably is saying is theirs? That don't even make sense. I wasn't born yesterday. Now, can I continue? I got points to make. Now, just like you just said, the THC was allegedly found next to some identifiers. I have copies. And according to the criminal complaint, it says the THC was found next to a landmark credit union identifier and a Western Union identifier with my name and that address on it. Well, I have copies of those identifiers right here. And neither one of those identifiers that the criminal complaint lied and said that it had my address on, that address on it, has that address. So that's a plain out motion to dismiss right here. You should be ready to throw this case out. It's a bogus, Ken Correa, whatever his name, the person who had nothing to do with my case but swore to the criminal complaint. That's a statement that he made inside the criminal complaint, and I'm proving to you that it's false if you're interested in hearing the truth.
And then, let me make my point here. That's why you need an attorney. An attorney would have made a motion at the time the complaint was filed, knowing or alleging that those were false, and then there's a whole body of law that applies to whether or not that affects the validity of the complaint or not.
Objection.
So you're 3 years late at this point in filing that kind of a motion, right?
Objection. I just received these papers. I requested these papers since 2015. I just received them from evidence on December 8th. So the only reason why I haven't made this argument is because the state was illegally concealing these documents from me, and then on December 8th, 2017, they finally gave them to me. And so I submitted them as exhibits, thinking that the prosecutor is going to exercise her discretion of Supreme Court ruling 20.3.8, section 3.8, and relieve me of these fictitious charges. And yet, every time I submit some evidence that liberate me from these fake charges, they act like the evidence is irrelevant, or they just plain out overlook the evidence. So here we are again. I never get it, even with Lieutenant Chad Showman. He allegedly escorted 252 grams of THC that came up missing and never was submitted into evidence. And through the time the THC come up missing, voila, 3 days into my jail, I'm sitting in jail on just a PO hole. Next thing I know, I got these mysterious THC charges that somehow ended up in evidence that was not found in my person, but found at somebody else's residence.
We're going around in a circle at this point. I'm going to order that the motions you filed, any new motions you made today are denied. For the reasons I've already stated on the record, we're not going to get anywhere with this. You're just going to keep going around in the circle and going back to issues you've raised before. There has to be an end to motions that you bring. You keep bringing motion after motion after motion. And we need to get this case resolved. It's been 3 years trying to deal with a pre-trial today, and you keep filing motions about this and that and everything else. And we'll do those things that I've suggested. The state's going to file jury instructions by the end of the week.
Objection.
The state's going to file a witness list by the end of the week and provide it to you and to the court. We'll have voir dire questions submitted in writing to the court by, there already were actually, I have the states, and if you want to submit some you can. If you don't, that's fine, you don't have any. I've talked to you about your right to an attorney and found that you waived it by your conduct and by your choice to go forward on your own.
Objection.
I've also talked to you about whether or not there should be a discussion about the last offer that was made, and you don't want an offer, you want a jury trial or dismissal. We talked about Lieutenant Chad Shulman, and those reports will be available to you in the manner I've described. The state's going to search to see whether there are any pre-employee interviews and write a letter to the court and to you about what they find, and then we can deal with that later on. And then we have a new date for jury trial, October 30th. And now we're going to set a date before that, maybe 2 weeks out, for a final pre-trial.
Well, look here. I would like to get some information about these officers, because when I had someone serve them subpoenas, the Racine County Sheriff Department would not accept them. We read the law. We're not stupid. Even though y'all will believe.
We're doing a new date now, okay? Just hold on. For a final pre-trial.
I can set it October 18th at 1:30.
Okay. Does that work for the state, Ms. Johnson?
Yes.
Okay. Mr. Barker, does that work for you?
Yes, but I would like to elaborate on, you keep trying to state for the record like this whole 3-year process is my fault. They're the one who was holding. If they give me all the discovery.
No one said it's your fault. Obviously, this is a process involving a judge, prosecutor, defense, and everyone takes responsibility for a case, and I'm trying to move this case along to conclusion as best I can. And I'm sure that other people did the same, and there are obviously just different obstacles that have occurred here. I'm not gonna point fingers at anyone, I'm not pointing fingers at anyone.
Well, you stated for the record like it's my fault. Look, I don't have Discovery, not because I don't got it, it's because they won't give it to me. I requested it, I filed records. Yes, I keep filing motions because they keep doing corrupting stuff that violates my constitutional rights. Lieutenant Sherman been under investigation for 10 months. They supposed to have been told me that. I just found out on July 6th about it. So of course I'm going to file a motion afterwards when they give me this late information. And then a week or so before that, she says, well, I want to adjourn your trial. But I thought everybody was so antsy to get to trial so fast. And then they're withholding evidence, destroying evidence.
All right, so we have a date for a final pretrial on October 18th at 1:30, and a date for a trial on October 30th at 8:30, okay?
So if I go and get a paid attorney, what is you saying? That I can't pay for attorney?
You can pay for an attorney, it's up to you. If you have an attorney, I'm encouraging you to get one. It would make it a lot easier for all of us,
I know
quite
you-
frankly, if you had an attorney. It would be much, much easier for all of us. The trial is a difficult process, as I told you before. You've got to understand what sorts of questions are appropriate to ask jurors in the process of voir dire. You've got to understand how you go about deciding which jurors you want and how many you can strike, from the jury panel that we have. You've got to know how to make an opening statement. You've got to know how to make a closing argument. You've got to know how to question witnesses, handle objections. It's not an easy thing, and I'm urging you, for your benefit, more than anyone in this court, to get an attorney if you can. And I selfishly know that it will make my job a lot easier as a judge if you have an attorney represent you as well.
I bet it will.
So, okay, so matter's concluded. We'll see you on those dates. Thank you.
Objection. So, hold on now. How am I supposed to get these records? So you saying I'm supposed to go down to come down here?
Let me stop, we're off the record. When will you produce them to the case manager?
I would need at least a week. to get them.
Okay,
Can you give a specific date?
yeah, give us a date by which you'll have them in the hands of Amy Vanderhoff, who's the case manager for criminal cases. And we're gonna give you a telephone number where you can reach her, Mr. Barker, once she has them, to set up a date to come down here to look at them. And she'll arrange for a place for you to sit and look at the reports, page by page. But again, you're not to take
I don't-
pictures of them.
I don't want to talk to anybody. I would rather everything be exchanged through email for record. Because y'all tend to play dumbfounded when I need a document, something, I done been all around Racine County, all the way to Walworth County chasing after documents, and I never get a chance to get them. So, y'all continue on violating my constitutional rights.
Yeah, this isn't the sheriff's department, this is the clerk of court's office.
I've been here across the street, Walworth County DA office,
Right.
Sheriff Records Department, I done been to all of them.
3311.
It is, I worked.
Here's the number you call. The name of the person is Amy
I
Vanderhoff.
know exactly who she is.
Okay, and then, what's the date you'll have them there by?
August 7th.
So after August 17th, call Ms. Vanderhoff and make arrangements to come down here. She'll find a place for you to sit down with those reports and to read them through, okay?
Yeah, I'll be down here with
All
the
right.
attorney.
Okay.